Let us all welcome all our eminent guests with a round of applause. I'll request everybody to rise and welcome all our eminent guests for the inaugural ceremony of International Conference on Comparative Law. Let the applauses be rolling as we have our chief guest for the day, Honorable Justice Deepak Mishra, sir, retired Chief Justice of India, Honorable Mr. Justice Rituraj Avasthi, Chairperson, Law Commission of India, Honorable Mr. Justice John Alexander Logan, Just Federal Court of Australia, who's joined us online, Guest of Honor Professor Dr. Manoj Kumar Sinha, Vice Chancellor, Dharma Shastra National Law University. Let the applauses be rolling, everyone. Dr. Cecilia Ines Selberberg, Embassy Counselor and Consul Argentina Embassy. We have with us our Chairman, Professor Dr. D.K. Bandyopadhyay, sir, Joint Directors, and Joint HOIs, Professor Dr. Aditya Tomar, sir, who's also the convener. Where are the applauses? Yes. We also have with us Dr. Shifali Raizada, Additional Director, Joint HOI, Amity Law School, Noida. I welcome the luminous dais once again. Thank you, everyone. I request everybody to be seated. Yato dharmas tato jaya. That is, where there is dharma, there is victory. The Constitution of India gives wide-ranging powers and jurisdictions to do complete justice between the parties, to bring to life this motto of the Indian Supreme Court.
Certainly, ma'am. Indian jurisprudence has witnessed intense legal practice and comparative law scholarship growth in the last few decades. Global developments, transnational governance, and complex economic interdependence, aided by the development of new communication and information technologies, have contributed to making the legal profession more contemporary in the scope than ever before. Comparative law, therefore, though as old as law itself, has become the tremendous significance for the growth of modern legal societies.
I shall conquer the untruth by truth, and in resisting untruth, I shall put up with all sufferings. Quote Mahatma Gandhi. A very good morning, all the respected dignitaries, esteemed guests, deans, HOIs, HODs, faculty members, friends across the globe, ladies and gentlemen, and my dear students. On behalf of Dr. Ashok K. Chauhan, Honorable Founder President, Amity Education Group, we extend a very warm welcome to all of you at the 5th edition of International Conference on Comparative Law, hosted by Amity Law School, Noida, in collaboration with School of Business and Law, Edith Cowan University, Western Australia. Let us all begin this ceremony with the lighting of the lamp. I'll request all the honorable dignitaries to kindly proceed to light the ceremonial lamp. And with this, we invoke the goddess within.
Om Saraswati Namo Namah, Ma Saraswati Namo Namah, Vidyadayani Namo Namah, Hansvahini Namo Namah. Om Saraswati Namo Namah, Ma Saraswati Namo Namah, Vidyadayani Namo Namah, Hansvahini Namo Namah. Om Ishardi ma, Ishardi ma, Agyani se namitari ma.
Let us have a round of applause for this invocation. Thank you, Shalja, for the wonderful rendition. With this, we invoke on the right path, that is the Dharma, that would enlighten us and guide us towards immortality. Thank you, everyone. Ladies and gentlemen, it's a tradition at Amity that we welcome our guests with Tulsi saplings. At Amity, modernity blends with tradition. And to begin with honoring and welcoming our guest, I'll request respected Professor Dr. D.K. Bandyopadhyay, sir, Chairman, Amity Law School, Noida, to welcome and present a Tulsi sapling to our chief guest for the day, Honorable Mr. Justice Deepak Mishra, retired Chief Justice of India. Welcome, Honorable Justice. I'll request Chairman, sir, to do the honors. Thank you, Honorable Justice Deepak Mishra, sir, for gracing the occasion. Presenting a Tulsi sapling showcases a green initiative at Amity University. Thank you so much, sir, for gracing the occasion. And Chairman, sir, for doing the honors. I'll also request Chairman, sir, to present a shawl to Honorable Justice Deepak Mishra, sir. Thank you so much, sir, for gracing the occasion. In the same breath, I'll request Honorable Justice Rajesh Tandon, sir, Additional Vice Chairman, Amity Judicial Academy and Amity Law Foundation, to present a Tulsi sapling and a shawl to Honorable Mr. Justice Rituraj Avasthi, Chairman, Law Commission of India. These green saplings always remind us that this is a green world, a green planet. Presenting a shawl showcases a love and warmth for you, respected sir. Thank you so much for gracing the occasion. I'll now request Professor Dr. Aditya Tomar, sir, and Professor Dr. Shefali Raizada, ma'am, Additional Directors and Joint HOI, to present a Tulsi sapling and a shawl to Professor Dr. Manoj Kumar Sinha, Vice Chancellor, Dharma Shastra National Law University, Jabalpur. Thank you so much, sir. You've been a mentor to Amity Law School, Noida. Thank you so much, sir, for gracing the occasion, and ma'am and sir for doing the honors. In the same breath, I'll request Professor Dr. Aditya Tomar and Professor Dr. Shefali Raizada, Joint HOIs and Additional Directors, to welcome and honor Dr. Cecilia Ines Silberberg from the Embassy and Consul Argentina Embassy. Welcome, Dr. Cecilia, to an international conference on comparative law. Thank you so much, sir. I'll now request Dr. Aditya Tomar, sir, and Dr. Shefali Raizada, ma'am, to welcome our chairman, Professor Dr. D.K. Bandyopadhyay, sir, with a sapling. I request Aditya, sir, and Shefali, ma'am, to further welcome and honor our chairman, Professor Dr. D.K. Bandyopadhyay, sir, with a sapling. Sir has been a mentor to all of us. He continuously motivates us to rise on the path of success. Thank you, Chairman, sir, for always being there for all of us at Amity Law School, Noida. Thank you, sir. In the same breath, I'll request Professor Dr. Aditya Tomar and Professor Dr. Shefali Raizada to welcome and honor our own honorary professor and additional vice chairman, Amity Judicial Academy, Honorable Justice Rajesh Tandon, sir, with a sapling. Thank you, Honorable Justice Rajesh Tandon, sir. Your endeavors at Amity for promoting Amity Judicial Academy is really praiseworthy. Thank you so much, sir, for gracing the occasion. Honorable Justice Logan, if you can see me and hear me here from Amity University, Amity Law School, Noida, we welcome Honorable Mr. Justice John Alexander Logan, Judge, Federal Court of Australia and National Courts and Supreme Court of Australia. So we welcome you with this Tulsi sapling from Amity Law School, Noida. Can we have a round of applause for Justice Logan? Sir is watching us from Australia. Right now, sir is in Brisbane in his office. Okay. Sir, there is a video which we would like to present to you, but I think there is some technical error. But I'm sure you are with us throughout the event. Thank you so much, sir, for gracing the occasion.
Thank you, ma'am. Ladies and gentlemen, esteemed faculty members and eager students, it is with great, it is with great pleasure and honor that we extend a warm invitation to a distinguished academician, Professor Dr. Aditya Thomas, sir, presently serving as the Additional Director Joint HOI of Amity Law School, Noida. Dr. Toma is an versatile personality, a versatile scholar with interdisciplinary interests contributing significantly to the field of law and academia. Dr. Thomas' commitment to research is evident in his supervision of PhD and LLM candidates, fostering a culture of academic excellence. His
Dr. Aditya Tomar is also the conference chair of this conference. Dr. Aditya Tomar.
Good morning, everyone on the dais, off the dais, and virtual platform. I welcome one and all to the 5th International Conference on the Comparative Law hosted by Amity Law School, Noida, in collaboration with School of Business and Law, Adit Kovind University, Western Australia. On behalf of brimming spirit and zeal of organizing committee, I warmly welcome our eminent guest for today, Honorable Mr. Justice Deepak Mishra, sir, former Chief Justice of India. Sir is an epitome of great legal acumen and mettle that envisages effective delivery of justice and source of inspiration for all of us. Honorable Mr. Justice Ritu Raj Avasthi, sir, Chairperson, Law Commission of India, and former Chief Justice, High Court of Karnataka, who heartily agreed to present his address today. Thank you, sir. Thank you very much. My hearty welcome to Honorable Justice John Alexander Logan, Judge Federal Court of Australia, who have took time despite his busy schedule to address all the delegates of conference. Many thanks, respected sir. I heartily welcome Professor Dr. Manoj Kumar Sinha, sir, Vice Chancellor, Dharmashastra National Law University, who has been our guiding light since the inception and source of inspiration always. Thank you, respected sir, for your gracious presence. In a spirit of my most humble gratitude, I warmly welcome Mrs. Cecilia and Cecil Borg, Embassy Counselor of Council Argentina Embassy. I welcome you, ma'am, to gracing the occasion. My most heartfelt thanks to our Honorable Founder President, Dr. Ashok K. Chauhan, sir, with whose blessings, love, and support we continue to make all the differences in the world by instilling in us the value of hard work, inspiration, social outreach, so we can create a just society for the present and future generation. I also thankful to our Honorable Chancellor, Dr. Atul Chauhan, who believes that together we can change the world. And at MIT Law School, Noida, the cause of changing the world is based on the dispensing justice and make all the stakeholder in legal fraternity walk in tandem with this spirit. I'm deeply honored and humbled by the trust endowed upon us by the great leader of higher education of our times, our Honorable Vice Chancellor, Madam Professor Dr. Balvinder Shukla, who has always motivated us, and even today, due to his despite busy schedule, he spent some time. Thank you, ma'am. Welcome. My hearty thanks to our Honorable Chairman, Dr. D.K. Bandyopadhyay, sir, who have been greatly inspired us and great leader of higher education, and with whose motivation Amity Law School Noida is growing each day on the global canvas. My also thanks to Honorable Mr. Justice Rajesh Tandon, former Judge Uttarakhand High Court, and presently Additional Vice Chairman, Amity Judicial Academy, Amity Law Foundation, and who have been through support system for all of us at Amity Law School Noida. Thank you, sir. My most humble welcome to our dear friend, Dr. Joshua Anaston, Associate Professor, Associate Dean of Law School of Business, Adit Kovind University, Western Australia, and conference co-chairperson, who has been our side in every academic endeavor that we do. Thank you, Dr. Joshua. all the delegates of the conference, faculty members, and the students. And sorry. And thank you all in attendance, all the inauguration ceremony, both in the online mode and offline mode here on campus. Laws are evolved and developed in many ways, comparing the laws of different nations and even cultures provided for the unique way of develop law in a better manner. Comparative law is one such method which describes the comparisons between the different legal systems. As the world shrinks into a global village, trade and commerce knows no boundaries. There are trade economic related issues as well as the scientific issues, especially in terms of space exploration, where international consequences becomes very important. And for such agreement, the knowledge about the rules and regulation of the different countries plays a crucial role. Comparative law has evolved over the years and has provided for the very significant method to analyze the laws of other nations. It becomes important to analyze and understand the different ways in which the legal mechanism can be understood. The core part of every law around the world is based on the same principle of justice and equity. The execution and understanding of the laws thus become crucial. Also now, when the world has started and invested in India via Make in India concept, it becomes very important for us to compare the legal systems of various jurisdictions. Further, more deliberations would be done during two-day grand conference. Once again, on behalf of entire organizing committee, I warmly welcome to all the attending and presenting in this conference. My most humble welcome to all dear friend Dr. Joshua and Austin, Associate Dean of Business and Law, Western Australia, who has been our side in every academic endeavor. Thank you, Dr. Joshua. Thank you all who join us virtually, physically. Thank you. Thank you very much.
Thank you so much, Professor Dr. Aditya Tomar, who's also the conference chair of ISCCL 2024. Ladies and gentlemen, I quote Maria Child, who says, "Law is not the law if it violates the principles of eternal justice." Having said so, it's a proud privilege to have none other than our Honorable Vice Chancellor, Professor Dr. Balwinder Shukla ma'am amongst us today. I'll request Professor Dr. Aditya Tomar and Professor Dr. Shefali Raizada ma'am to welcome our Honorable Vice Chancellor ma'am with a Tulsi sapling. Thank you so much, ma'am. In spite of your so much busy schedule, we all know there are so many things going on in the university today. Ma'am has taken out time to address us. We are so touched with your presence, ma'am. Ladies and gentlemen, Professor Dr. Balwinder Shukla ma'am, a dynamic individual with a unique sense of leadership. Madam is an educationist and a leader and a source of inspiration for all of us. A person who aims to perfect each and every Amitian is none other than our own Honorable Vice Chancellor, Professor Dr. Balwinder Shukla, an epitome in the field of education, research, innovation, social outreach programs, spearheading so many things at Amity University and being coveted with hundreds of awards. I will now request Honorable Vice Chancellor, Professor Dr. Balwinder Shukla ma'am to present your address. Please welcome ma'am with a round of applause.
Very good morning. Good morning. Yes. A very esteemed Chief Guest of the Day, Honorable Mr. Justice Deepak Mishra ji, Chief Justice of India, retired. A very esteemed Guest of Honors, Honorable Mr. Justice Rituraj Awasthi ji, Honorable Mr. Justice John Alexander Logan ji, and Professor Dr. Manoj Kumar Sinha ji, Vice Chancellor of the Dharamshila National Law School, Dr. Cecil Silberg, Embassy Consular and Consular of Argentina Embassy, my very esteemed colleagues, Professor Bandyopadhyay, the heads of Amity Law Schools. I'm extremely privileged to extend very warm welcome to our honorable chief guests of honors, and the distinguished speakers for the day, and the delegates and the audience for the International Conference on Comparative Law 2024 in collaboration with the School of Business and Law, Edith Cowan University. And I've been saying that we started this comparative law conference in collaboration with the Adelaide University, and later on with the Edith Cowan University, and year after year we are organizing this. So we'd like to thank our partners for this very important conference, and especially when we talk about the comparative law, it's important for the law graduates and the student to understand what are the different laws of the different countries, because the businesses happen across the globe. The manpower migrates across the borders. So there are the various laws which are applicable, whether it's related to finances or for the manpower or the business, how the interests of the organizations, the countries can be taken care by the legal fraternity. So therefore, for the everyone, it's very important what changes are coming and how we prepare ourselves while we are representing our country or the companies in the national or international forums, and especially when the dispute arises, at that time it's become very important. So I was going through the experts, the panelists, and such a great luminaries are there, the legal and as well as from the academic world. And I'm sure this 2 days, the conference is not only going to bring the uh, new insights into the comparative laws, but it's also going to help in building the collaborations for research, for academics, and I'm sure with the Edith Cowan University and Amity Law School are going to work out the collaboration. Many other areas, the research, student exchange, faculty exchange, and many of the students. We'd like to also see that how the students can understand the laws of the other countries and prepare themselves so they are able to practice in the other countries. So a lot many initiative Dr. Bandyopadhyay ji along with his team has taken, that how to prepare the students uh, for the practicing in the other countries. And especially today it's very busy day, but I wanted to personally meet our distinguished guests, Honorable Justice Deepak Mishra ji, Honorable Mr. Rituraj Awasthi ji, Honorable Justice John Alexander Logan ji, and Professor Sinha, because today we are starting our January batch PhD program, and 11:30 we have the Havan, because our Honorable Founder President always believes that if you take the blessings of Almighty before starting anything, you're bound to get the success. And for us, and for, as per Honorable Founder President, each student be the success story, and we are seeking the blessings of Almighty before starting the PhD program of January batch. And my advice to all the students here, please take the notes, all the speaker what they speak, because those you will not get easily in the books. And these are the experiences of so many years by practicing the law, and those learning you must take, because those will be very handy and useful for you. And our Honorable Chancellor have always emphasized on that, and his mission is that how the Amitians can contribute to the at the global level and contribute in a manner that they make this world, bring the changes and make this world a better place to live. And this is a great opportunity for all the students. Our honorable founder president have always emphasized that if anybody visits the Amity, and especially in conferences like this, means that person has, mission to develop the future talent. And that future talent who will not only contribute for their own career, but they will be contributing to the nation building from the whichever profession they choose to. And I'm very thankful to our esteemed guest today that you have spared. I know that most of you have visited the Amity in the past also. And you're repeatedly visiting Amity University show that you really want to make these young leaders of the future successful leaders, and how they can remember you always, that the learning which they have got from you will go long way in their life. Whenever they will be practicing or doing anything, they will remember that in so and so conference and so time we have learned such things from so and so experts. So you will be always remembered. And once again, I extend very warm welcome to all our esteemed guests. And Dr. Silberg, I'm extremely thankful to you, and I would like to discuss with you something that how we can build a collaboration with the various organizations, especially the universities in your country, and look forward future association with you and the various organizations from your this country. With this, I congratulate Dr. Aditya Tomar, Dr. Shafali Rai Dada, Dr. Bhanu for putting in this wonderful conference under the great leadership of Dr. Bandyopadhyay ji, who minutely goes through all the programs, and I am sure this program will give the enriching experience to all the students. So thank you very much.
Thank you so much, ma'am. We are blessed with your beautiful words. Today, we have with us Honorable Justice Sri Rajesh Tandon. Rajesh Tandon, sir, started career practicing as an advocate in the year 1968. He has held several important positions under the Constitution of India. Justice Tandon was appointed as the senior advocate in the year 2000, Honorable Judge of the High Court of Uttarakhand in 2004, Presiding Officer, Cyber Regulation Appellate Tribunal, Delhi in the year 2006. And Sir's achievement are as follows. Uttarakhand High Court at Nainital, former Chairperson, Cyber Appellate Tribunal, Government of India, former Chairman, Admission and Fee Committee of Private Educational Institution, Uttarakhand, former Vice Chairman, Amity Institute of Cyber Law and Cyber Crime, Uttar Pradesh, former member, Human Rights Commission, Uttarakhand, former Chairman, Uttarakhand State Law Commission. Justice Tandon has also authored 4 books in law and has also been awarded prestigious Sahityak Puraskar on the famous book Muslim Vidhi in Hindi by the government of Uttar Pradesh. And presently, we are honored to seek Sir's blessings and guidance as the additional Vice Chairman of Amity Judicial Academy and Amity Law Foundation. Please, sir.
Will request Honorable Lordship to present his address.
Thank you very much, Master of Ceremonies, Sri Aditya ji and Dr. Sumitra ji, both Master of Ceremonies. Thank you very much. On the dais, His Lordship Justice Deepak Mishra, Honorable Chief Justice of India, my elder brother, Justice Awasthi, my brother, colleague. On the dais, our Chairman, Vice Chancellor, and Dr. D.K. Bandyopadhyay, the Chairman of the Law School, Sri Aditya Tomar, the conference organizer, 5th conference organizer, and Dr. Silberg, Embassy Council and Council Embassy. Now, Sri Manoj Kumar Sinha, the Vice Chancellor of Jabalpur University. John Alexander, the Federal Court of Australia, who is online. Our Chancellor and our Founder President, Dr. Ashok K. Chauhan, from whom blessings the program has been organized. Now, I am thankful to our Founder President for the organizing this program. Amity University is a leading international research private university and has been recognized by the University Grant Commission, being a worldwide branches of Amity University. I call the founder president, Dr. Ashok K. Chauhan, as a Vish Guru in the field of educational field, because so many branches are at worldwide branches in the India as well as outside the country. Very soon, our founder president is taking initiative to start the work of Judicial Academy, which will be imparting the education for the law students to appear in the examination of the judiciary. The result will be that a student of law, after completing his degree, will shift to the judiciary. This will be the first attempt of our founder president amongst the other universities. Now, coming to the subject, comparative law is a method for the study of laws of different countries. It includes various processes such as analyzing the laws and comparing them on a different basis. It emphasizes on the legal mechanism being adopted by the countries and compares them. Comparative law is not a legal text or body of rules. It is more of a method, and therefore it is regarded as a complete encyclopedia of the legal branches. Now, coming to the comparative law is a way to build a basic foundation through which laws all over the world operate. There are trade and economic related issues as well as scientific in terms of space exploration, where international concepts become very important. G20 has been an example of the international comparative theme for which India has a privilege to host the events as a presidency. G20 summit theme was Vasudhaiva Kutumbakam, or one earth, one family of one future. This is based on the Article 51 of the Constitution. Article 51 promote international peace and security. G20 was outcome of this preamble of our Constitution, that is Article 51, promote international peace and security and maintain just and honorable relations between nations. The comparative law also works for that. Now, Amity Institute has organized various programs concerning G20 by organizing various seminars on science and technology. Now, coming to the subject of comparative law and human rights, which I have chosen as one of the subjects amongst the 4 subjects, I divide the same through various acts, the origin of which has come up from international trade and commerce, and the same has been enforced after taking into consideration the various aspects of globalization in the international conferences. Now, before I come to the various laws, I may just uh, demonstrate before you regarding the human rights, that is comparative law and human rights, which is the subject of mine. Let us take the human rights, which is a part of seminar in connection with the comparative law that was formed. Protection of human right has the origin from right from 12,015, followed by Magna Carta in England, and thereafter in 1945, delegates from 50 countries met in San Francisco, full of optimism and hope, the goal of the United Nations Conference on International Organization. Now, thereafter, the Universal Declaration of Human Rights, which we observe on 10th of December 1948 as a Universal Declaration of Human Rights. We celebrate 10th of December as a Human Rights Day. Thereafter, in 1966, the adoption of the International Covenant on Economic, Social and Cultural Rights, the International Covenant on Civil and Political Rights was introduced in 1966, and thereafter in after 1966, now we have observed Declaration of Human Rights as article at par with Article 21 of the Constitution of India. Protection of life and personal liberty, which is Article 21, and the Human Rights Section 2D also defines the human rights means the rights relating to life, liberty, equality, and dignity of the individual, guaranteed by the constitutional. And similarly, some international covenants were also introduced, means the International Covenant on Civil and Political Rights, that was also the creation of United Nations Conference on that. Coming to the comparative criminal law and human rights, we cannot forget the observations of the Honorable Supreme Court in the matter of Kapila Hingorani versus 2003 volumes, SCC volume 1. Now, in this judgment, their lordships of the Supreme Court has said, in any organized society, right to live as human being is not ensured by meeting only the animal need of man. It is secured only when he is assured of all facilities to develop himself and is freed from restrictions which inhibit his growth. All human rights are designed to achieve this object. Right to live guaranteed in any civilized society implies the right to food. अभी हमें कुछ time लगेगा. Right to food and right to food, water, and decent environment. These are the international forum where the human rights was enforced, right to food and all that. Now, relying on the various judgments of the Supreme Court, D.K. Basu case and all that, that is comparative criminal law. D.K. Basu has also emphasized that how to arrest a person and all that. These are the judgments of the Supreme Court. I may quote that in Australia also, all jurisdictions, there is a strong presumption in favor of granting bail. Recently, I have also read in the newspaper, the Supreme Court has also said that the bail is a right. And human rights is also very prevalent in the Australia, where although there is no separate act, but human rights are being followed in Australia also. Now, coming to the second origin of the international convention, that is that has come up from a model law of the UN, that is Information Technology Act, that is model law, which is known as the Information Technology Act, that is also being recognized universally, that is also word-wise Information Technology Act. There are some places where only the Information Technology Act is prevalent, and some places that is law of that is similar law also prevailing. Therefore, these are the two laws which are internationally original. The third comes, that is another comes, that is the international, that is IPR, that is also international originated laws, and they are being followed worldwide. They are being followed. Just like taking example, that is intellectual property rights, that is copyright, was initially was brought into that 1914 by United Kingdom. There is also a law, patent law. Patent law is fully organized by the MT University, and Osho has said once regarding patent that learn from sensation and observe it, and further the human mind is effort oriented, action oriented, obsessed with activity. These are the patent, which is the copyright and patent are being recognized, worldwide recognized. And therefore, our environmental law is also a worldwide, and that is being obeyed either in Australia, UK, and everywhere. And these are the symptoms of original laws, that is Human Rights, IPR, and Information Technology Act. These are the laws which are worldwide laws. Apart from that, since the time is left, no time is left, I will just quote a Gita and 2 lines of Gita. मात्र कर्म अपने लिए करना बंधन है, संसार के लिए करना सेवा है, और भगवान के लिए करना पूजा है. थैंक यू वेरी मच.
Thank you so much, Your Lordship. Beautiful address, and that reminds me of Domitus Alpine, who says that justice is constant, a perpetual will to allot every man his due. And what is that? That is justice. Having said so, ladies and gentlemen, joining us online, none other than Dr. Joshua N. Aston, Associate Dean and Conference Co-Chair, School of Business and Law, Edith Cowan University, Western Australia. Dr. Joshua, can we now have you for your address? Can you see me?
Yes, I can see you. Can you hear me?
Yes, so we can. Please welcome Dr. Joshua Aston for his address.
Thank you very much. Thank you, Dr. Sumitra Singh. It is truly an honor to have this opportunity to speak to you all, and especially this esteemed gathering of jurists, academics, practitioners, bureaucrats, and scholars, both joining in person and virtually. And while I express my genuine delight, I must acknowledge the sense of disappointment as circumstances prevent me from joining you all in person today. But nevertheless, my team and I remain fully committed to participating in spirit throughout the duration of this conference. The chief guest, Honorable Justice Mishra, guest of honor, Justice Avasthi, distinguished guests on the dais, and those joining us virtually, ladies and gentlemen. It is indeed a pleasure and honor to co-host the 5th International Conference on Comparative Law with Amity Law School, Amity University, Noida. And this conference really stands as a testament to the power of collaboration and the pursuit of knowledge across borders. Now, my friends would know, and I always have consistently emphasized, that rather than serving as a barrier, the Indian Ocean serves as a conduit that actually binds India and Australia together. And the collaboration between Amity University and Edith Cowan University hosting this mega event for the 4th consecutive time exemplifies its notion of connectivity and cooperation between the two nations. I would say that it stands as a shining example of how geographical distances can be bridged by academic partnerships and shared endeavors. Now, for those who do not know, Edith Cowan University is nestled in the vibrant city of Perth, based in Western Australia, and it is the only university in the continent to be named after a woman. She was Edith Cowan, the first Australian woman to serve as a member of the parliament here. I am delighted to see that our university and Amity University, which is a beacon of academic excellence in India, have forged this remarkable partnership. And this collaboration is bound by a memorandum of understanding. It exemplifies the spirit of international cooperation and mutual growth. And together, these institutions have actually transcended, I would say, geographical barriers going above and beyond in research and collaboration, truly embodying the spirit of being a natural partner. Now, as a representative of the Council of Australian Law Deans, which is the peak body of all 39 law schools based in Australia, I bring forth a heartfelt appreciation and warm wishes to all involved in organizing this stellar conference. The exponential growth we witness today, with nearly double number of paper presenters compared to previous years, speaks volumes about the rising prominence and popularity of this conference. And with participants and keynote speakers hailing from all corners of the globe, this conference has truly evolved into an intellectual feast, something that I've already started enjoying after hearing to some of our speakers who already started, especially in the field of comparative law. That remains the topic for today. Now, to all the paper presenters, I extend my sincere congratulations and best wishes. Your dedication and scholarly pursuits and contribution to this conference are commendable. I have had a chance to look at some of the abstracts, and I can confirm that each presentation adds a unique dimension to our understanding of comparative law, and it enriches the collective knowledge of our community. I would also, in the same breath, like to extend the gratitude to the moderators, the keynote speakers, and the management team at Amity University for their excellent management and tireless efforts in ensuring the success of this conference. It is through this, basically through their dedication and hard work, that the vision and the platform continues to thrive and inspire generations of legal scholars. In particular, I'd like to thank Professor D.K. Bandyopadhyay, Professor Aditya Tomar, Professor Raizada, Dr. Jane Matthew, Dr. Sumitra Singh, Mr. Rupendra Singh, and all hands who've made this event successful. I express my sincere thanks to the senior management, the President, Mr. Ashok Chauhan, the Chancellor, Mr. Atul Chauhan, and Professor Balvinder Shukla, the Vice Chancellor, for their outstanding dynamic leadership and in particularly promoting such collaborations. In closing, I would only like to say that as we embark on this 2 day of engaging discussions and scholarly exchange, let us embrace the spirit of collaboration and learning with mutual respect. My colleagues and I from this part of the globe will be keenly participating in this endeavor. And may this conference serve as a catalyst for further exploration and innovation in the realm of comparative law. Thank you very much, friends. Thank you for your indulgence. And I really wish you a fruitful and an enriching experience ahead. Over to you.
Round of applause for Dr. Joshua. All these applauses are for you from ICCL 2024 conference. Well, everybody who's joined us online and everybody who's here, it is said that once an Amitian is always an Amitian. And Dr. Joshua, I think I can see that indomitable Amity spirit in you ever since we met 5 to 6 years back. I can see that you are a thorough Amitian. Thank you so much for being the co-chair of ICCL 2024 conference and strengthening our bonds of friendship all these years. Once again, a round of applause for Dr. Joshua. Thank you so much, sir.
Thank you, ma'am. There is but one law for all, namely that law which governs all law, the law of our Creator, the law of humanity, justice, equity, the law of nature and of nations. Ladies and gentlemen, and esteemed faculty members, aspiring students, it is with great honor and enthusiasm that we extend a warm invitation to a distinguished figure in academia, Professor Dr. Dilip Kumar Bandyopadhyay, sir. With a career spanning over 40 years, he is a renowned professor, scientific management researcher, and an exceptional academic administrator, currently serving as the chief advisor to the founder president's office of Amity Group of Institutions. A visionary leader in India's education community, Professor Dilip Kumar Bandyopadhyay is a gold medalist in his master's degree, holds a PhD in computer applications. His impactful leadership continued as the Vice Chancellor of IP University from 2008 to 2013, where he disruptive innovative changes in the technical and professional university, overseeing almost 70,000 students.
So good morning to all of you. जोश नहीं लग रहा है. Good morning to all of you. Because there is a proverb. The proverb says, well begun is half done. What else can be well begun? When the dawn of the legal field, legal luminaries are sitting on the dais, and they are all quoted. Justice Deepak Misra, Chief Justice of India, Supreme Court, and his verdict, his rational human verdicts, interpreting the different facets of the societal requirement, has made a great footprint in the Indian legal justice delivery system. Now, his presence as a chief guest, the presence of Justice Osti, who is the chairman of the Law Commission, spanning his entire career in the justice delivery system, now giving a direction, new direction, and try to understand what are the different societal changes that are taking place and how to capture the societal changes. Sir, Dr. Misraji and Dr. Avastaji, we are really thankful to you. And I welcome both of you on behalf of our entire Amity universe, on behalf of our Honorable Founder President, on behalf of our Chancellor, on behalf of our Vice Chancellor, on my personal behalf, that you are able to spare some of your time to come over here, to bless the student, and also give us a guidance of how to conduct this multi-collaborative international conference on comparative law. My friend, my brother, rather I would say, Professor Sinha, illustrious career in international law, heading India Law Institute for his term, now taking over as a NLU director of Jabalpur or Dharmshala National Law University, Jabalpur, a great academic thought leader, and people do look after his research methodology book. And we all refer his research methodology book that he has written for the conduct of the research in the field of law. Now, Joshua, I do not know how to thank you, because I don't want to thank you because you are a part of us. You are our honorary professor. Please remember when our honorable founder president agreed that yes, here is a person whom we shall honor with the honorary professor, and you have really made the mark of becoming an honorary professor, and that's the way how we are connecting each other, and that's the way for the last 4 years we are conducting this international conference. Now, I also welcome Celia Ines Saibalbar, who is the, embassy counselor and consulate of Argentina embassy. And I came to know, madam, that you are also in the field, from the field of law. You are also looking forward and also teach international law before taking over as a counsel. So we look forward for our immense collaborations while you are in India and while you go back to Argentina. Before that, we shall like to have collaborations with you, with Amity Law Schools and the Argentinian law schools. Dear students, why we are doing it? I come back to the point. Because our founder president, honorable founder president, all the time says, you must know what you are doing some activities. What is the purpose of these activities? Conference, you do it. People come over there. Many of them, they take it as a celebration. They're going out of the workplace and coming to a place where they can exchange their views and ideas, doing the networking, and go back. Certainly, these are going to be there. But in addition to that, what we feel that what is going to be the outcome, what will be the take home from these conferences. So comparative law nowadays, you know that has become so much importance with the advancement of the technology, with the advancement of the commerce, with the advancement of the crime. Commerce and crime are borderless. So whatever crime is taking place elsewhere, it has a repercussion to India or repercussion to other countries. Now there comes the point, what are the laws are in existence? And we have seen in the deliberation of the high courts and Supreme Courts, the laws of the other countries are being quoted very repeatedly. And there are also changes that are taking place. Sir, you are sitting over there from the Law Commission. There are lots of changes that's taking place in our own law. Now, new law which has been enacted, we can see that there are lots of changes that are taking place to bring the Indianness, India requirement, not forgetting what is going to be the repercussion in the international world. So we must understand what has been happening elsewhere. What are the best practices they are doing it? What are the best ways the justice delivery systems are being provided over there? Whether it's a trade law, whether it's a company law, whether it is a business law, whether it is going to be the motor vehicles law, whether it is going to be their procedural laws, what are the different things they have been doing it and successfully they have been doing it. Can we contextualize it in our Indian context? Can you take into considerations of those dimensions? So there comes the importance of the comparative law. So dear students, please take advantage of this learning. More than 350 papers came over and we have shortlisted them with a rigorous screening, and those who are going to be presented in the conference, either online or offline. So please take all advantage. Develop your inquiry of mind, because inquiry of mind will be leading to your better litigation. If the inquiry of mind is not there, then you will be only doing all the case laws that has already happened and you will not be able to bring newness. And we want newness in the justice delivery system. We want that the new technology, new environment, India becoming the fifth in the global economic power, going to be third in the global economic power. What are the necessary changes that demands to be brought in our legal system? And then that also comes from the study of the comparative law. I mean, try to add value to yourself, enjoy the conference. Wherever you find some topics are interesting to you, go and sit over there or listen them. There's a link has also been provided over there. Add value to yourself. And then this will also help you in writing your dissertation. This will also help you of doing or writing different articles by yourself. And we want to see that bubbles to come. And that's the reason we are conducting this conference. We are bringing many intellectuals together over here, and they are giving their thoughts. You question those thoughts, because in academics we all the time say agree to disagree is the essence of the development of academics. And similarly, in the justice delivery system also, the arguments that are being provided over there, unless and until we are able to bring different types of newness to that, then the delivery system, the judges, honorable judges who are sitting over there to provide the justice delivery system, they also start feeling the same घिसे पे टैक्सेस हो रही हैं. What is the newness that we are bringing in our argumentative process, in our arguments? So this is the important, that is the thing that we have learned from our honorable founder president, Dr. Ashok Kechwa. He all the time says, be the leader, never be the follower. So all of you must synchronize your thoughts with his thoughts and be the leader. So wish you all the best. Thank you.
Good morning, Honorable Justice Logan. Can you see me? Good morning, sir. How are you? Up the dais, we have with us all our guests. All the luminous dais, please meet Honorable Justice Logan from Australia. Welcome to ICCL conference, Lord, my Lord. And we are beginning, we are following the schedule, and we have our guest of honor now lined up. Thank you, Chairman, sir. Uh, Chairman sir's beautiful words always tell us one thing: Paramity is as good as you make it, and wherever you go, your name with Amity will remain forever.
Well, it is an immense honor and privilege to stand before you today as we prepare to welcome a legal luminary whose contributions to the judiciary have left an indelible mark on the landscape of justice in our nation. Our distinguished chief guest for today, none other than Honorable Justice Deepak Mishra, sir, the former Chief Justice of India. Justice Deepak Mishra's remarkable journey in the realm of law spans decades, and his dedication to upholding the principles of justice, fairness, and constitutional values has been exemplary. Throughout his illustrious career, Justice Mishra has been at the forefront of landmark decisions that have shaped the landscape of our country. His commitment to protecting the rights of every citizen and ensuring the sanctity of the judiciary is an inspiration for all aspiring legal minds. Some of his landmark judgments that have changed the legal landscape of our nation are the Kaveri case and many others. Sir, we request you to please address the gathering.
Please welcome Lordship Justice Deepak Mishra, sir, with a roaring round of applause.
Dignitaries on the dais, dignitaries of the dais, my young friends, whom I always love to call jars in law. Jars means you are the Russian jars. Great. Friends from the electronic and print media, ladies and gentlemen, before I start, I would like to address this side. Please raise your hands, not the faculty members, who would like to enter into an agreement with me. Please raise your hands. None of you. I would like to raise your hands. It's an agreement, oral agreement, executable. The clause of the agreement is this: you shall gladly lend me 15 minutes of your time, and I shall obligedly speak to you for 15 minutes, not a second more than that. Right? Anyway. Yes, I'm delighted. I must tell you that I really feel glad when I come to the amiable atmosphere of the Amity University. The topic is comparative law, but I have chosen to speak on the comparative constitutional law and various facets of it, and what a student is required to do. You see, this emergence of comparative constitutional law as a distinct field of study with legal education is attributable to several historical and intellectual developments. So the development took place because of globalization, interconnectedness, sense of belonging. You know what is sense of belonging? When you are sitting here, you are seeing me and listening to me. And my sense of belonging is that I talk to you as a person connected with you. If that is absent, we do not belong to each other. The question of comparative constitutional law is absolutely absent. Therefore, my request to you, get involved, get connected, belong to the subject. Today, in the 21st century, the effects of universal connectivity and sense of belonging have strengthened the bond among nations, the bond among individuals, the bond among the groups, the bond in the collective. The influence of international treaties, agreements, covenants have become more crucial in shaping nations' perceptions of their individual rights, traditions, and constitutional norms and values. There is a growing sense of urgency to analyze constitutional issues through the comparative constitutional law prism by amplifying the significance of interdisciplinary collaboration and infusing it with renewed vigor. May I pause here for a while? Why I say renewed vigor? The world is changing. The world is on the path of continuous change. I'll go to the ancient philosophy and I'll ask a question. Every one of you should be ready with the question. There is a blind man. There is a man who can't hear, a deaf man. There is a man who is taking the load, and there is a respectable lady. And there is a king. Go back 2000 years back and please tell me, on the road, who shall have the first right? Ma'am, can you answer? Or you? Anyone can answer? Wrong. Who said the blind man? Right. Any other option? Second. Who will have the second right? Yes, yes. You seem to be coming with an answer. Anyway, first right is that of the blind man. The second right is that of the deaf man. Third right is that of the man who is carrying the load on the road. And fourth right is that of the lady, respectable lady. And the fifth right is that of the king. The shloka reads like this. Andhasya panthaha, badirasya panthaha, bharabahasya panthaha, strihu panthaha, rajyaha panthaha. Very simple. I don't go into the last part. I don't intend to touch that. Just see that analogy and see the comparative law, the constitutional law. This is conceptually means doctrine of inclusiveness, unless which our organic document encompasses under various articles. The same feature you will find in USA Constitution, in Australian Constitution, in South African Constitution. So I gave you the ancient principle, the present principle, and the comparative principle. Now, let's come to the certain modern facets in a different way. A significant facet of transplantation of constitutional principles has disseminated specific features of the United States Constitution, including Bill of Rights, doctrine of judicial review over legislation, administrative acts, and the imposition of constraints on the executive through principles of equal protection before the law and substantive due process. The rulings of constitutional courts in South Africa, Canada, New Zealand, Australia, and India have emerged as the primary navigator behind the increasing significance of comparative constitutional law. The methodical examination of this branch of law and the jurisprudence across nations have witnessed their resurgence when constitutional courts have placed reliance on the comparative constitutional doctrines and principles. You see, United States of America, in the case of Lawrence versus Texas, said that a criminal, please try to understand and connect criminal punishment to all forms of private, consensual, non-procreative, adult sexual activities between two individuals are unconstitutional. This has a separate kind of plank in contradiction, distinction to our understanding of choice, but eventual conclusion is the same. That is where the Supreme Court of India, while dealing with the constitutional validity of Section 377 of the Indian Penal Code, declared that it's unconstitutional because it creates a dent in the privacy, it creates a dent and affects choice, and additionally, it really tries to corrode the individuality of an individual. That's precisely the US court had spoken in different kind of language, adding certain other conditions which were not necessary here. In another case, that is Rupert's, the US Supreme Court made an extensive reference to comparative constitutional prospects while holding that it's unconstitutional to impose capital punishment for crimes committed while the person is below the age of 18. We have the Juvenile Protection Act here, 1986, amended from time to time. And the law stands clear today. A juvenile really cannot be punished in this kind of manner. He may not be sent to jail unless it's different. There has been some amendment, I understand, as far as the murder, rape, and concern, and other the situation. Then it will be tried as an ordinary accused. But there is also an age bar. So the constitutional comparability and acceptability between the two democratic polities are evincible if you really keenly study them and appreciate them. I know a student of law studies for Marx, isn't it? While studying for Marx, do never forget that you are also subserving your intellect. Never, never, my dear young friends, mortgage your intellect to anything else. Intellect is prime. Intellect can subserve to your concerns on certain occasions, which I am not addressing today because that's not the subject. I still have 7 minutes more. You people don't have a sense of humor, as it seems. Comparative constitutional law serves as a tool for introspection by drawing analogies distinctions, and contrasts among different legal systems. The premise is that while nations governed by the doctrine of rule of law, nations face similar constitutional challenges. They may employ diverse approaches to address them, to solve them, but the comparative study is peremptory. I may state here that metamorphosis or transformation of anti-regressive constitutional norms have introduced a healthy idea that it is appropriate and opposite not to confer any definition to the concept of rule of law. You see, when I mean to say, what I mean to say is this: rule of law. Who is in the third year law here? Any student who is in third year law? Okay. You are taught rule of law? Right. Don't try. There are many academicians once assembled in Delhi sometime in 2013 to define rule of law. My sincere request to them was, please do not define rule of law. The counter question was, unless you confer a definition, the rule of law as an idea, as a concept, as a conception would become an unruly horse. No. Rule of law, don't define. Do not give it a boundary. Because rule of as an idea shall rule supreme. Do not confine it by giving it a definition, and that is a part of the comparative law. No jurisdiction has given it a definition that way. Now, come back to another ladder. Multiple and varied definitions may give rise to different thoughts, but the basic grammar does not change as long as state intends to remain as a contemporaneous constitutional democracy, as it is the expression of legitimacy under the protective umbrella of rule of law. One impressive aspect that has been highlighted is the supremacy of the Constitution, or which may be called the sovereignty of the Constitution. And that is where the doctrine of basic structure stands with strength and comfort, and the citizenry breathes in amiable space. All the jurisdictions what I have studied in my humble way, UK, Canada, Australia, and US, have progressed extensively in interpreting constitutional provisions for pragmatic application by following the necessity to achieve constitutional supremacy. When I say constitutional supremacy, when I mean neither you are the great person nor am I a great person, but it's the Constitution. And that is where you will get when you study quite keenly and sharply the comparative constitutional law. The United States, the Supreme Court of United States in Marbury case introduced the idea of judicial review over legislation, that it can declare a particular law as unconstitutional if it invites the frown of any of the provisions of the Constitution. And that became the lifeblood of polity of United States and its democracy. In our Constitution, as we see, the fundamental principles of justice, liberty, equality, and fraternity serve as the bedrock of democratic society. However, as we confront the complexities of the 21st century, it has become quite imperative to contextualize our constitutional framework in the global context. As you are living in a global village, the concept of planetization has come into quintessence and you can't ignore it. You see, I was trying to study how many cases have in Supreme Court of India have referred to the foreign jurisdictions. I found in various fields, constitutional field, corporate law, tax law, like in Ramji Tech, I'm not giving in detail, the doctrine of repugnancy, in particular Nicholas text judgment, the Australian jurisprudence was followed in a different way, elaborated, not that the Indian jurisdiction did not have, but you have to really progress with time. That is how. And Right to Information Act, the young children are very interested nowadays to have the information because they think it's a fundamental right and it's in a way a fundamental right. And the Australian High Court, please, I'll read this passage. Have you got the patience? There are some notes, so I take it as yes. Look at the language, how the scene is painted. The relationship between the modern state and its citizens is so different in kind from that which exists between private citizens that rules worked out to govern contractual property, commercial and private confidences are not fully applicable where the plaintiff is a government or one of its agencies. Private citizens are entitled to protect or further own interest, whereas governments act all events are constitutionally required to act in the public interest. Information is held, received, and imparted to governments, their departments and agencies to further the public interest. Public and not private interest, therefore, must be the criterion by which equity determines whether it will protect information which a government or a governmental body claim to be confidential. So, government cannot say it's confidential. No, it must try to establish a larger public interest. In comparative law, fundamental or first principle is lesser public interest must yield to, must given, must surrender to larger public interest. And this is called public interest test. Have you heard of euthanasia case as young law students? Yeah. In euthanasia case, the Supreme Court of India said, right to die is not a fundamental right, but right to die with dignity is a fundamental right. The nuanced distinction, the subtle distinction is featured in each of the judgments. And there is copious reference to judgments from South Africa, UK, and Australia. I do not intend to refer to Maneka Gandhi, that was in 1978, but I must say that copiously refer to the various judgments in the comparative constitutional field and really opened the vistas of understanding the acts of the executive and the legislatures, how you can really get into and penetrate into and also interfere. Remember this. Thus, comparative constitutional study enriches the understanding of the fundamental grammar of constitutional law. It contributes to the ongoing discourse on constitutional theory, practice, and reform in a democratic body polity. I am sure the present conference shall enhance the contributory aspects in the academic sphere, and for the same, the Amity University, its faculty members, the organizers, the vice chancellors, and the chancellor deserve to be congratulated. And the audience, the courteous audience, the silent audience deserves to be appreciated, congratulated, and I say so from the core of my heart. Thank you. Thank you very much for your kind courtesy. Thank you.
Let's have a huge round of applause for our chief guest, Your Honor, His Lordship, Honorable Mr. Justice Deepak Mishra, sir, former Chief Justice of India. Thank you so much, sir, for your beautiful and highly glistening golden legal intellectual discourse. Well, justice will prevail, and so the rule of law will prevail. Having said so, let's now try to understand the Australian discourse from none other than Honorable Justice John Alexander Logan, Judge, Federal Court of Australia. Justice Logan was commissioned into the Australian Intelligence Corps in the Army Reserve in the year 1976, and he held the rank of the Major in that corps before transferring to the Standby Reserve. He was awarded the Reserve Force Decoration in 1993 in respect of his military service. He graduated from the University of Queensland with a Bachelor of Economics and Bachelor of Laws, and he was admitted to the Queensland Bar in the year 1980 and was then working with the Commonwealth Crown Solicitor's Office in Brisbane. He commenced his private practice at the Queensland Bar in 1984 and was appointed as the senior counsel in the year 1999. Justice Logan served as the deputy president, formerly known as presidential member of the Administrative Appeals Tribunal, from November 2010 to 2020, and that period of service included acting as a tribunal's president for some weeks. Let's now welcome with a huge round of applause our guest of honor, Honorable Justice John Alexander Logan from Australia. These applauses for you, Your Honor. Can you see me and can you hear me? Over to you, sir. Would request Justice Logan for his address.
Yes, well, good morning from Australia, where it is good afternoon. You have heard, as I have, a very thought-provoking address from India's former Chief Justice on a public law dimension to comparative law. My privilege today is to offer you a perspective on a private law aspect of comparative law. I had an earlier privilege this week of attending and delivering a keynote address at the invitation of the Attorney General for India at the recently concluded Commonwealth Legal Education Association and Commonwealth Attorneys and Solicitors General Conference held in Delhi. It was through our mutual attendance at that conference that Associate Professor Singh came to extend the invitation to address you. The theme of the conference at Delhi was cross-border challenges in justice delivery. India's hosting of that conference is an indication of a leadership role which India can and demonstrably and successfully did play in the modern Commonwealth. The modern Commonwealth offers a bridge between countries of common heritage and shared values in relation to their legal systems. This conference between an Indian law school and an Australian law school sits nicely within the collaboration between Commonwealth countries fostered by the Commonwealth Legal Education Association. Although our common heritage is manifested in common law-based legal systems and a separation of powers between the legislative, judicial and executive branches of government, the international trade and commerce in which each of our countries ever increasingly engage has long extended to commercial relations with countries of other than common law heritage. Further, the formation of contracts governing such trade and commerce has been facilitated as never before by the internet. So too, one might add, would be addresses of this sort. What follows in my remarks is the subject of a paper, a short paper, which will be distributed via Associate Professor Singh after the conclusion of my remarks. So there's no need to take notes, but rather just to absorb the rhythms of what I'm going now to say. In combination, the considerations that I've just mentioned as to interchange between common law heritage and non-common law countries in international trade and commerce, facilitated by the internet, means that ever increasingly our respective legal professions, Australia and India, must, in their training and continuing legal education and in practice, have an understanding not just of the common law in relation to the formation of contracts, their construction, and remedies for their breach, but also of basic civil law concepts concerning the like subjects. The Attorney General for Singapore, another common law jurisdiction of shared heritage, made just such a point in his address to the Delhi conference. Singapore proposes to include in its undergraduate law curriculum a compulsory subject concerning basic civil law concepts. Thus, this collaborative conference focusing on comparative law is both timely and apt. A way of exemplifying in the limited time available for my remarks the practical relevance of understanding civil law concepts is to share with you my experience in determining a major contractual and related trade practices, alleged misleading or deceptive conduct in that regard, a dispute between an Australian-based olive oil producer and a German-headquartered manufacturer of highly specialised equipment for the supply, installation and commissioning of an olive oil production line. The case concerned is Olival Proprietary Limited and Flotweg GmbH. I give the citation in my remarks. A subsequent appeal for my judgment in that case was dismissed, and I give the citation for the appeal judgment in each case with paragraph references pertinent to what I'm now going to say. One issue in the case concerned the meaning and effect of a so-called warranty, which provided for a, quote, reasonable period of grace, unquote, and a, quote, reduction in price, quote, unquote. The phrase reasonable period of grace was not one I had encountered before, and by that stage I'd been in practice either in a government law office or at the private bar for some 27 years, and a judge for about 2 years. So I just hadn't encountered them in the better part of 30 years. The phrase reasonable period of grace was just not one I'd encountered before. Neither, as became evident from their submissions, had counsel for each of the parties. That was not through lack of ability, for each party was represented by a silk, senior advocate, if you will, in India, and able junior advocate. Rather, it was because both bar and, prior to that case, bench were unfamiliar with civil law concepts. Aided by the pervasive searching that's possible via the internet, I came to appreciate that reasonable period of grace and a reduction in price were civil law concepts. Via Benjamin's sale of goods, I found that these concepts had been taken up in the United Nations Convention on Contracts for the International Sale of Goods. I'll call that Vienna Convention. That led me to an article by a Mr. Nicholas, the Vienna Convention on International Sales Law, in the Law Quarterly Review. I give the citation of that in my remarks in writing. Mr. Nicholas, by way of background in that paper, discussed these civil law concepts. In turn, that led me to make, in the course of my reasons for judgment, these observations. From this discussion, in other words, the discussion in the Law Quarterly Review article, it emerges that the ability of a party to fix an additional time for performance, i.e., the allowance of a reasonable period of grace, is often referred to in civil law as the Nachfrist, N-A-C-H-F-R-I-S-T, from its partial similarity to a German institution of that name. Mr. Nicholas remarks of the Nachfrist that during the period named, the party fixing the period cannot resort to any remedy for breach of contract. Apart from this, the direct legal effect is confined to cases of failure by the seller to deliver or by the buyer to take delivery or to pay the price. In these three cases, if the failure remains unremedied on the expiry of the Nachfrist, the other party is entitled to avoid the contract, regardless of whether the breach is fundamental or not. I'll interpolate there that you might well understand from your common law studies that a right to terminate for breach of contract would ordinarily arise in our common law systems only for fundamental breach. To return to the quote from the judgment, in other words, the Nachfrist relieves the party from the risk that the original breach might be held not to have been fundamental, or rather substitutes for that risk the smaller risk that the length of the Nachfrist may be held to be unreasonable. As to reduction of price, this, Mr. Nicholas notes, is familiar to civil lawyers and derives from the action quanti minoris of Roman law, the civil law alternative right of rescission also owes its origin to Roman law. Actio red habitoria. Now, the civil law was not directly relevant in this Australian case, Olivale and Flotweg. Further, although the Vienna Convention had been incorporated by statute into Australian domestic law, that incorporation permitted the parties to exclude its application. The parties had availed themselves of this by excluding its application in their contract. Nonetheless, civil law concepts had found their way into the terms of the contract in the way I've just mentioned. That was not surprising given that the manufacturer was headquartered in a civil law jurisdiction, Germany. Absent an understanding of civil law concepts, it would not have been possible to do justice between the parties in the construction of the contract. In the result, I concluded that the applicant had sought to withdraw from the contract and obtain a refund of the purchase price prior to the expiry of the reasonable period of grace. That outcome was upheld on appeal. The Vienna Convention itself also illustrates how civil law concepts can find their way into international treaties. That they do should be unsurprising, because the parties to such treaties may be drawn from civil law and common law jurisdictions. Once incorporated into domestic law, it matters not that these concepts might be foreign to the common law. By this route also, a lawyer in a common law heritage jurisdiction may be required to advise clients and perhaps make submissions in court of law.
Your Lordship,
These
Lordship,
civil law concepts.
Your Lordship, Justice Lagan.
Yes,
Wouldn't-
just about finished.
Yeah.
Thus, comparative law, the study of other legal systems, is not in a country of common law heritage a field of abstract academic discourse. It has, and is ever more likely to have, practical significance. I thank each of the universities, and you in particular, Associate Professor Singh, for the privilege of addressing this conference, highly relevant conference, and sharing with you an experience from practice and life as a judge about why comparative law truly is relevant in practice. Thank you, and good morning, or as the case may be from Australia, good afternoon.
Thank you so much, Lordship. Your Honor, our chairman wants to tell you something. Chairman, sir? Actually, our chief guest, Your Honor, His Lordship, Honorable Justice Deepak Mishra, sir, has to leave for another meeting. So I'll request Chairman, Professor Dr. D.K. Bandyopadhyay, sir, together with Dr. Aditya Tomar, sir, together with Dr. Shafani Raizada, ma'am, to present a token of love and gratitude to Your Honor, His Lordship, Justice Deepak Mishra, sir. This is a token of our gratitude, warmth and love from Amity Law School, Noida. Thank you so much, sir, for gracing the occasion. We are so touched with your glistening words of legal intellectual discourse. And Amity Law School, Noida continues to grow under your mentorship. Thank you so much, Honorable Justice Deepak Mishra, sir, for gracing the occasion. Chairman, sir, for doing the honors. In the same breath, I will now request Dr. Cecilia Ines Silberberg from the Embassy, Counselor and Consul Argentina Embassy to present her address. Ms. Cecilia.
Hi, good afternoon to everybody. Thank you very much, both University, Amity University, and Ethico One University for organizing this wonderful conference, particularly to Professors Singh and Matthew for inviting me. It's going to be like a very brief presentation because it's kind of late for everybody, but I just wanted to point out two things. First of all, I'm here as in my professor, international law teacher capacity. And so my presentation has two main points. First of all, to try to transmit to you what is important of comparative law in international law. And in the second term, to give you a concrete example that perhaps you might have lived during the pandemic. The relevance of comparative law is enormous. And why so? Because international law subjects, mostly states, when they have to regulate a right or a situation, they need to look for what the other states are doing about the subject. And that it's a very important thing, because that gives you a legal frame to work. Perhaps that legal frame is not as perfect as you wish or as it could be, but that helps you too. Because if it is good enough, it gives you an objective, a way to regulate. And if it is not, it gives you the opportunity to surpass the main obstacles that legislation has. And also, it helps you to analyze your own regulation, because sometimes states regulate with cultural bias, or perhaps it helps you to see in others cultural biases. So that also gives you a whole perspective to work on. And I give you an example. During the first year of the pandemic, I did a research for the Hague Academy of International Law. And what I had to research about was the data protection right and the use of technology. And thanks to many comparative law studies, we realized that there were so many right privacy violations around the world because of the use of technology. Was kind of so sorry about that. It was it wasn't a surprise really, because the pandemic was so huge, so unexpected, so universal, that the states didn't know how to cope with the situation. So they used technology. And even though analyzing only democratic governments, democratic states, we realized that the majority of those decisions, the decisions using technology for cope with the virus, there were a lot of discretionary and arbitrariness. And it's just because they didn't follow the rule of law principles and the principles of good governance. So, and that had a very practical consequence. People from states that didn't follow, didn't trust in their governments, didn't use the technologies, tools that their governments tried to implement during the pandemic. So great answers to cope with the virus weren't used because people didn't trust in their governments. They didn't trust in what their governments would do with the data they would collect. So this is the main conclusion was that in the majority of the cases that discretionary and arbitrariness was because states didn't have a legislation regarding the use of right of privacy or regulating data privacy, the right of health and use of technology. And among that was comparative law studies conclude also that one of the big issues was that the right to personal data protection wasn't recognized as independent human right. In the majority of the countries, or universally speaking, only besides Europe, which had regulated, in the rest of the world, normally is part of the right of privacy. So what happened after the pandemic? Many states, as you've seen in India too last year, started to regulate the right to privacy. So that is because two things. First of all, because we learned, but second thing, because we compare what other states were doing about it and try to prevent same consequences. So to conclude, because I know that I had only 3-4 minutes, just to say that comparative law studies are of the utmost importance, and you can't regulate a subject nowadays without taking care about those studies. And this is not an abstract thing. It's as an example I've told you, using the right tools could have saved many lives and of course could have protected better human dignity. So thank you very much.
Thank you, Ms. Cecilia, for those beautiful words. Very touched with your presence.
Thank you, ma'am. It is with great pleasure and immense respect that we extend a warm invitation to the stage for a distinguished personality in academia, Professor Dr. Manoj Kumar Sinha, the Vice Chancellor of Dharmashastra National Law University.
Thank you very much. And I have 2 minutes, and 1 minute I'll take on the acknowledging the respect and honor given by MIT Law School for inviting me. And I have been coming here for last 5 years for this particular program. I was thinking that I'll get a chance after Justice Deepak Mishra to speak, because whenever Lord Justice Deepak Mishra speaks, so he covers everything, and next speaker has to struggle to find out what he is going to speak on the dais. So much has been said on this subject, and little bit remain. I think I'll leave it for the Honorable Justice Ritu Rajavasti sir, is the chairperson of the Law Commission of India. The 2-3 important points which I have gathered from the presentation by various scholars today, and particularly on the importance of the comparative law, and Lordship has emphasized on the comparative constitutional law. It's very important, and what we see, and even in the MIT Law School and other law school, a subject has been introduced in the 2013, taking note of what we are discussing about law and justice in globalizing world. So when we teach in the law and justice in globalizing a world, we focus on the increased interdependence among the states. So states and then we start examining whether states' sovereignty is remain sacrosanct or it has been increased because of the interdependence. And that connection we see comparative law in the human rights, comparative law in the trade law, comparative in the environment law, all aspects, and more importantly in the cyber law, we say interdependence have increased. I'm happy that university has been thinking about this subject and continue to pursue it vigorously to ensure that all is we understand the nuances of the comparative public law, and it should be taken seriously. The last point which I have, and which I takes to the Justice Rajesh Tandon sir, when he spoke about the International Covenant Protection of Human Rights Act. So I suggest that Section 2D of the Protection of Human Rights Act, which has a dimension of the both international law and national law. Particularly when we look into the definition, it says human rights is defined as a rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution. And the same paragraph, it talks about or embodied in the international covenant enforceable by courts in India. So when we look into the definition, we see the importance of the comparative law in the perspective of human rights. I just end here by once again thanking Aditya Tomar and the MIT Law University for giving me a chance, and I hope that we'll have more other occasions to speak in detail in this subject. Thank you very much.
Thank you so much, Professor Dr. Manoj Sinha, sir, for your continuous mentoring to ICCL 2024. Ladies and gentlemen, in the dynamic landscape of the legal affairs, the Law Commission plays a pivotal role in shaping and reforming the legal frame of our nation. Under the leadership of His Lordship Justice Rituraj Avasthi, sir, the Law Commission has been at the forefront of addressing contemporary legal issues, ensuring the evolution of our legal system to meet the challenges of the issues.
His Lordship, Shri Rituraj Avasthi, brings a wealth of experience and a profound understanding of the intricacies of our legal structure. His dedication to the cause of justice, coupled with a commitment to legal reforms, has made a significant impact on the legal discourse in our country. We warmly welcome Justice Rituraj Avasthi for his address.
Professor Dr. D.K. Bandyopadhyay, Dr. Manoj Sinha, Vice Chancellor of NLU Jabalpur, Dr. Sisla Sinberger, Professor Dr. Aditya Tomar, Dr. Rajada, ladies and gentlemen, esteemed guests, distinguished friends who are physically present as well as who have joined us virtually, my dear students, good afternoon. I am deeply honored to stand before you today. My topic for deliberation today relates to the theme number 2, that is comparative constitutional law. Very apt analysis has been given by Justice Deepak Mishra on the topic. So I will touch upon only the other aspects of this topic. And I have been given 10 minutes slot for this. And I will try to be within the time to finish my speech. Once a minor and obscure adjunct to the field of domestic constitutional law, the comparative constitutional law has now moved to the front and center. The prominence and visibility of the field, both among judges and scholars, have grown exponentially, particularly in the last decade. The Rig Veda says, Ano Bhadra Katvo Yantu Vishwata, which means let noble thoughts come to us from all directions. The phrase insulates a profound sentiment emphasizing openness, receptivity, and willingness to embrace wisdom from diverse sources. In the broader context, the phrase promotes the values of inclusivity, intellectual curiosity, and the continuous pursuit of knowledge, as noble thoughts have the potential to enrich and elevate our collective understanding, transcending geographical, cultural, and ideological barriers. Just as noble thoughts are valued regardless of their source, the comparative analysis of constitutional framework allows for a broader perspective, facilitating the identification of effective constitutional principles, practices, and innovations, embracing noble thoughts from all directions in the context of comparative constitutional law, emphasizes the importance of learning from the experiences of different jurisdictions, promoting a more robust and globally informed approach to constitutional design, interpretation, and reforms. As a subject, comparative constitutional law is a specialized area of legal inquiry that involves the systematic examination and comparison of constitutions from different countries. This field uncovers similarities, differences, and trends in constitutional principles and structures across diverse legal systems. The study of comparative constitutional law is thus crucial for gaining insights into the functioning of constitutional democracies, identifying common challenges, and fostering cross-cultural understanding. By exploring different approaches to constitutional governance, this field contributes to the development of legal theory and helps inform policymakers and legal practitioners around the world. This subject firstly provides a broader perspective by allowing scholars and policymakers to examine and understand different constitutional frameworks and governance structures across various countries. This comparative approach helps identify best practices and innovative solutions to common problems. Secondly, it facilitates the exchange of ideas and experiences between legal systems, fostering cross-cultural understanding and collaborations. By studying how different nations address similar constitutional issues, it becomes possible to appreciate diverse perspectives and learn from each other's successes and failures. Additionally, comparative constitutional law can serve as a tool for constitutional borrowing of constitutional designs and reforms. Policymakers can draw inspiration from successful constitutional models and transplant them to their own context, promoting the development of more effective and responsive legal frameworks. I need not remind everyone how the Indian Constituent Assembly drew inspirations from several sources to create a unique document tailored to the country's historical, cultural, and political context. The Indian Constitution, adopted in 1950, borrowed elements from various legal traditions, embodying a blend of British, American, and other constitutional influences. The parliamentary system of government, federal structure, and the concept of an independent judiciary with the power of judicial review are some of the examples of British constitutional principles incorporated in the Indian Constitution. The parliamentary model, with a strong executive accountable to the legislature, reflects the British system, while the fundamental rights and the idea of a written constitution draw inspiration from the United States. Additionally, the directive principles of state policy in the Indian Constitution reflects the influence of the Irish Constitution, incorporating socio-economic goals for the state. The concept of fundamental duties chapter in the Indian Constitution is a unique feature that draws inspiration from the Constitution of the Soviet Union. The framers of the Indian Constitution were deliberate in their approach, adopting the incorporating provisions that they believed would address the specific needs and challenges faced by the newly independent nation. Comparative constitutional law in this context served as a tool for informed decision making, allowing the drafters to assess the merits and drawbacks of various constitutional provisions and systems. While not seeking to replicate any particular model entirely, the Indian Constitution reflects the synthesis of global constitutional practices, contributing to the establishment of a comprehensive and contractually relevant governance framework. Once drafted onto a different constitutional system, the constitutional transplants can grow or evolve. One example of such adaptation is the evolution of the public litigations in India, using their inherent power under Article 32 and 226 of the Constitution. A few judges of the Supreme Court and High Courts made access to justice easier by adopting the concept of public interest litigation. Anyone acting in the public interest was permitted to file a petition on behalf of those unable to do so themselves or for issues of grave public importance. Thus, the migration of the constitutional ideas across legal systems is a rapid emerging as one of the central features of contemporary constitutional practice. It is my humble endeavor to shed some light on the best emerging criticisms of comparative constitutional law and how best addresses these concerns to enable an appropriate application of comparative constitutional law. To set the context right, I take the liberty to go back to the famous debate of the year 2005 between Justice Scalia and Justice Stephen Breyer of the constitutional relevance of foreign courts' decisions. To illustrate the challenges associated with blind transplantation of constitutional principles, in the course of this debate, Justice Scalia repeated his view, which he held in Prince versus United States in the year 1997, that foreign law should not be cited by domestic courts. On the other hand, Justice Breyer offered a pragmatic rationale for relying on comparative law, suggesting that it is very necessary for the other countries to adopt the judgments or cite them in their own cases when it relates to the same problem. Justice Scalia's opinion reflects one of the very commonly shared concern among lawmakers and judges that reliance on comparative law might actually turn court into agents of outside powers. According to Justice Scalia, applying foreign principles that have emerged in a different context and have been chosen by the people of that foreign nation may be akin to allowing foreigners to guide the application and evolution of one's own constitution and hence might be deeply undemocratic. In my opinion, the incorporation of constitutional principles from other jurisdictions is a practice that demands careful consideration, ensuring alignment with the underlying constitutional principles of the native legal framework, while drawing inspiration from foreign constitutional norms can enrich legal discourse and offer valuable insights. It is imperative that this integration remains contingent upon the fundamental principles embedded in the native constitution. The process should prioritize coherence and harmony with the constitutional ethos, avoiding any compromise to the unique values, historical context, and legal traditions that characterizes the native legal system. To summarize this argument, I have to crystallize that it is not always prudent to adopt the international court's judgments in the domestic perspective unless you understand the basic requirements and the basic contents of the problems, and applying to that you may use those judgments in your own problems. In order to understand, I may submit that let us take a toward the horizon of the reception of the doctrine of basic structure, which was crystallized in Indian legal jurisprudence 50 years back in the landmark judgment of Keshwanand Bharati. In the absence of explicit unamendability provisions in their constitution, the countries such as Pakistan and Bangladesh adopted the doctrine to put limitations on the adaptation and amendment power of their parliament. However, on the other hand, the plea for incorporation of the basic structure doctrine was rejected by the Kenyan Supreme Court in the recent judgment of David Nidhi versus Attorney General, popularly known as BBI judgment. These examples from Kenya and Bangladesh shows that the success and efficacy of transplants of constitutional ideas depend on their compatibility with the core intent and values enshrined in the respective native constitutions. This not only ensures the seamless integration of foreign ideas, but also safeguards the intrinsic character of domestic legal framework. These instances emphasizes the need for a judicious and context-sensitive approach when borrowing constitutional principles, reinforcing the idea that such incorporations should resonate with the foundational principles of the native constitution for a harmonious and effective legal evolution. Another crucial point which I want to wish to highlight is the selective nature of picking and choosing foreign case law when relying upon case laws from other jurisdictions, while drawing inspiration from foreign legal precedents can enrich legal discourse and offer valuable insights. The process of selection must be guided by a deep understanding of the underlying constitutional principles of the native legal system. Simply cherry picking foreign case law without considering its compatibility with the native constitutional ethos can lead to inconsistencies and dilute the integrity of the legal framework. To substantiate and submit this opinion, I would like to point out several anomalies which I could find in the recent judgment of the Indian Supreme Court in Kaushal Kishore versus Union of India, which heavily relied upon numerous case laws from jurisdictions across the world. What I want to emphasize is that legal systems are deeply embedded in the history, culture, and societal values of a nation, and blindly incorporating foreign precedents without due consideration can lead to inconsistencies in jurisprudence. This practice may inadvertently undermine the delicate balance established by the native legal system, eroding the coherence and predictability that is vital for the legal certainty. Thus, in my opinion, the creative interpretation of constitutions from a comparative perspective has brought in great convergence. However, it needs to be considered whether such convergence in itself desirable. Even today, there has not emerged a single constitutional arrangement that suits all the societies. Many questions, such as those pertaining to judicial review, remains unresolved, and the wide differences in social and cultural circumstances cannot be ignored. It needs special consideration that comparative constitutional law flows out of judicial interpretation may lack political morality. This power of courts to interpret the constitution are limited in the sense that the courts are duty bound to interpret the constitution as it stands and leave substantive changes up to the legislature. The law-making power and implicitly rest with courts is only limited to instances where constitution itself is ambiguous, vague, inconsistent, or silent. While foreign jurisprudence may be useful here in interpreting the existing provisions to fill such gaps. The courts in such situations cannot make substantive judicial amendments in the guise of interpretation, thus embracing ideas from other countries and coming up with new ways of doing things differently enriches our legal jurisprudence, but at the same time, it is really important for the courts and decision makers to be extra cautious. They need to make sure that in foreign ideas fit well with our own way of doing things, creating a legal system that's not just moving forward, but also stays true to our values, and what not just moving forward, but also stays true to our values, what people in our society needs. So by threading the needle between adaptation and caution, I believe we can pave the way for a legal system that stands resilient and just in the face of evolving global challenges. So with this, I end my presentation. Thank you very much. I want to express my sincere appreciation for the privilege of being invited to this 5th Annual International Conference on Comparative Law organized by the Amity Law School, Noida, in collaboration with the School of Businesses and Law, Edith Cowan University, Australia. Thank you very much. Jai Hind.
Thank you, Your Honor, Honorable Justice Rituraj Avasthi, for a wonderful discourse. Ladies and gentlemen, boys and girls, let's have a round of applause for all the speakers. Thank you, all the speakers, for a great intellectual discourse today at the inaugural session of International Conference on Comparative Law. It's time that we felicitate and honor our guests who graced the luminous dais for ICCL 2024 conference. Having said so, I'll request Chairman Professor Dr. D.K. Bandyopadhyay, sir, to present a token of love and warmth to none other than Honorable Mr. Justice Rituraj Avasthi, Chairperson, Law Commission of India. This is the token of love and gratitude from Amity Law School, Noida, Amity University, Uttar Pradesh, for ICCL 2024 conference. Thank you, Chairman, sir, for doing the honors. Justice Rituraj Avasthi for gracing the occasion. In the same breath, I'll request Chairman, sir, Dr. Shafali Raizada, ma'am, Dr. Aditya Tomar, sir, to felicitate and honor Professor Dr. Manoj Kumar Sinha, Vice Chancellor, Dharma Shastra National Law University, Jabalpur, with a token of her love and gratitude from ICCL 2024 conference, Amity Law School, Noida, Amity University, Uttar Pradesh. Thank you so much, sir, for gracing the occasion. Chairman, sir, and Joint HOIs for doing the honors. In the same breath, I'll request Chairman, sir, and our Joint HOIs to felicitate and honor Ms. Cecilia Ines Silberberg, Embassy Counselor and Consul, Argentina Embassy. Thank you so much, ma'am, for gracing the occasion. Chairman, sir, Aditya, sir, and Shifali, ma'am, for doing the honors. Let's have a roaring applause for all these felicitations and everybody who's joined us online. This is the time we felicitate and honor our guests from the portals of Amity University, Uttar Pradesh, Noida, a research and innovation-driven university. Ladies and gentlemen, boys and girls, and everybody who's joined us here and also in the online mode, it's time that we release some of our books that have been written, edited by eminent authors across the globe. And here in the row, we are to unravel the hard copy of the Amity International Journal of Juridical Sciences. Everybody who's here and joining us online, you all may send in your articles to the editors, Professor Dr. Aditya Tomar, Professor Dr. D.K. Bandyopadhyay, Dr. Devendra Singh. We also unravel the conference proceedings of the 5th International Conference on Comparative Law 2024, published by Bharati Publications. Together on the stage, you can see, as time stands still, in the honorable presence of Your Honor, Justice Rituraj Avasthi, Ms. Cecilia, and Professor Dr. Manoj Kumar Sinha. Thank you so much, ma'am and sir, for doing the honors. We also have release of some other publications. You can see up the digital portal, Springer Publications, Singapore, This is the Comparative Law Unraveling Global Legal Systems, edited by Dr. Joshua N. Aston. I'm sure you're watching us from Australia. Let's have a round of applause, edited by Professor Dr. Aditya Tomar, Mr. Rupendra Singh, and Dr. Joshua N. Aston. This is Springer Publications from Singapore. We come to another publication, that is a handbook on comparative constitutional law, published by Bharati Publications. Let us see on the digital screen here. This is the handbook on comparative business law, edited by Professor Dr. Aditya Tomar and Dr. Priyanka Ghai. Let's have a round of applause for that. So today we have released 5 books. Then that is the hard copy release of Amity International Journal of Juridical Sciences Conference Proceedings, Springer Publications Singapore, Handbook on Comparative Constitutional Law, and Handbook on Comparative Business Law. Let us have a round of applause for all the releases. Thank you so much, everybody, who've joined us in the online and the offline mode. And before we end the session, there is one thing to understand, that the arc of the moral universe can be long, but it bends towards justice. Ladies and gentlemen, as we wind up, I'll request Professor Dr. Shafali Raizada, Additional Director and Joint HOI, Amity Law School, Noida, to present the vote of thanks.
Very good afternoon to all esteemed distinguished guests for the day and all the faculty members, dear participants and students. We are now at the closing of this inaugural session of this great mega event, that is International Conference on Comparative Law 2024. I would take this privilege to convey my gratitude to all the esteemed and the distinguished guests. Rather, I should say, the entire galaxy of the academia platform here today on this occasion. First of all, my gratitude to our respected founder president, Sir, Dr. Ashok K. Chauhan, for providing these platforms where we can showcase our and nurture our talent. Thank you so very much, sir, for your blessings always with Amity Law School, and we feel proud to be an Amitian. I convey my thanks and regards to our chief guest for the day, former Chief Justice of India, Honorable Mr. Justice Deepak Mishra, for his gracious presence today. Certainly, we are obliged for his presence and time he has accepted and given the consent to be here. I thank our Chancellor, Sir, Dr. Atul Chauhan, for always being there to motivate us and to show the roadmap to create wonders in this dynamic world. I convey my regards and thanks to Honorable Justice Rituraj Awasthi, Sir, Chairperson, Law Commission of India, for his gracious presence. My thanks to Honorable Mr. Justice John Alexander, Judge, Federal Court of Australia, for joining the event. My thanks to the guest of honor, Dr. Sylvie Berg, Embassy Counselor and Consul Argentina Embassy. I also convey my gratitudes to our Vice Chancellor, Dharmashastra National Law University, Jabalpur, Professor Dr. Manoj Sinha, sir. Thank you so very much, sir, being with us. My special thanks to Professor Dr. Balvinder Shukla, Madam, Honorable Vice Chancellor, Amity University, and for such good platforms and the good wishes, directions to move ahead in our career and in our profession. A big thank you to Dr. Joshua N. Aston, Associate Dean, Conference Co-Chair, School of Business and Law at Cowan University, Western Australia. I believe this association will take Amity University and Edith Cowan University much ahead in the field of academics in times to come. And thank you so very much once again. Big thank you to our respected chairman, sir, Amity Law School advisor to founder president, sir, Professor Dr. D.K. Bandyopadhyay. Thank you, sir, for your all direction support, mentoring us, and as a navigator, as so-called the navigator of Amity Law School. Thank you so very much. Thank you all. Thank you. And regards to our additional vice chairman, former Justice Professor Rajesh Tandon, sir, for gracing this occasion today. And I convey my thanks to all the guest participants, students, dear faculty colleagues, and big congratulations to the organizing team. And thanks once again to the entire galaxy present over here. Thank you so very much.